Good day, Crime Talk aficionados. We have another great show for you today. First, prosecutors reveal new details on the Bryan Kohberger action and decisions to spare the roommate in the Idaho murders. Terrifying new mugshot released of the suspect in the Devil's Den murders. The judge's gag order in the Frisco stabbing case, a noble attempt at silencing the already echoing halls. Florida ascends to the pinnacle of peril on track to shatter its own macabre milestone in executions. Alec Baldwin's civil lawsuit against the prosecutors in his criminal case, well, it comes up firing a blank. This day in legal history, we have the legal quote of the day that has to deal with the two-tier legal system based upon money. And then finally, our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications. And remember, you can always check us out on any of your favorite podcasting apps. Now, before we get started, let me remind you to go to crimetalksearch.com and sign up for that background subscription service today. When you do, you'll be able to do as many background searches on anyone that you desire here in the United States. You're going to find out if the person has lots of different emails that they aren't telling you about, their social media presence. You're going to find out phone numbers. Do they have a burner phone? What would they be using a burner phone for? You're going to find out if they are married. Are they divorced? Do they have a criminal history? Are they on a sex offender registry? Yes, ladies and gentlemen, everything you want to know about somebody that's coming into your life, or whether you want to find out if somebody, well, if it's time for them to go. Go to crimetalksearch.com, sign up for that background subscription today. You're going to be happy that you did. All right, let's go ahead and get to the docket for Thursday, July 31st. Can you believe the month of July is almost over? Unbelievable. All right, first, prosecutors reveal new details. That's right, the prosecutors. So in a comprehensive interview following Bryan Kohberger's guilty plea and sentencing for the 2022 murders of the 4 University of Idaho students, Latah County Prosecutor Bill Thompson disclosed several previously unrevealed aspects of the investigation. These revelations shed light on Kohberger's movements during the crime, the prosecutor's evidentiary strategy, and the rationale behind accepting a plea deal that spared the defendant from the death penalty. Now, Kohberger admitted guilty, will forever be guilty, admitted to the killings earlier this month, receiving 4 consecutive life sentences without parole for the first-degree murders of Kaylee Goncalves, Madison Mogen, Xana Kernodle, and Ethan Chapin, plus throw on another 10 years for the burglary. Now, the murders occurred on November 13th in an off-site campus residence there in Moscow, Idaho, where the victims were stabbed to death in their beds. Now, Kohberger, the criminology graduate student at the nearby Washington State University, was arrested in December of 2022 at his parents' home in Pennsylvania. Thompson emphasized that DNA evidence left on a knife sheath at the scene was pivotal, describing it as critical to the identifying and charging of Kohberger. What have I been saying all along? Remember, everybody dismissed, not everybody, a lot of people dismissed it. Oh, the DNA is not true. Everybody knew it. The lawyers knew it. Kohberger knew it. That's how they prove identification, right? Remember, they have to prove that it was Kohberger, not somebody that looked like him, not someone using his identity, but it was in fact him. DNA, the ultimate identifier. Anyway, without this genetic match, the prosecutor stated that police might have struggled to build a case or even get an arrest. So, one of the most significant disclosures centered on Dylan Mortensen, one of the 2 surviving roommates who was present in the house during the attack. Now, Mortensen, who lived on the 2nd floor with Kernodle and Chapin, reported opening her bedroom door after hearing unusual noises and encountering a masked man, later identified as Kohberger, wearing this black clothing and carrying an unidentified container. Thompson confirmed that Mortensen's accounts remained consistent across multiple interviews, including her description of the intruder's bushy eyebrows visible above his mask. Now, Thompson theorized that Kohberger likely saw Mortensen, but chose to spare her life due to escalating panic. From what Dylan described, Thompson said, "I have a hard time imagining that the killer did not see Dylan. And at that point, he'd been in the house probably longer than he planned, and he had probably killed more people than he had planned. It wouldn't surprise us that the killer was scared at that point and decided they had to leave, not knowing if law enforcement had already been called." Now, this encounter occurred as Kohberger exited via a second-floor sliding glass door after the killings. Now, Mortensen delivered a poignant victim impact statement at Kohberger's sentencing hearing on July 23rd, there in Ada County. Anyway, seated at the prosecution table, she detailed the enduring trauma, stating, "What he did shattered me in places I didn't know could break. It's far beyond anxiety. It's my body reliving everything over and over again." At her request, Thompson positioned himself to obstruct Kohberger's view of her during the statement, a gesture he described as honoring her strength amid profound pain. Additional forensic details revealed that only 2 victims, Gonsalves and Karmelo, sustained defensive wounds, suggesting varying levels of resistance during the attack. Now, Thompson addressed misconceptions surrounding the DoorDash delivery driver as well during the interview. The driver pulled over for an unrelated traffic stop in September of 2024, claimed to have seen Kohberger and parked near his vehicle about 4 a.m. in the morning of the murders while delivering food to Karmelo. However, surveillance footage contradicted this statement, showing they encountered a different light-colored SUV and individual. And the prosecutors had planned to call her as a witness solely to establish the timeline, not to implicate Kohberger directly. Now, the vehicle and the person she saw that she thought might have been the killer is not Mr. Kohberger, Mr. Thompson clarified. That was a different vehicle, a different person at a slightly different time. While investigators have never recovered the murder weapon or a knife sharpener that Kohberger purchased on Amazon back in March of 2022, alongside his K-bar knife and the sheath. Now, had the case proceeded to trial, the prosecution intended to present a replicated K-bar knife as demonstrative evidence to illustrate the weapon's characteristics based upon the purchased records. Brian Kohberger has his knife for 7 months, and lost it. I got this in the summer of 1988 upon graduating from Marine Corps boot camp. Haven't lost mine. Same one. Look how broken it is. And look, I'm sure there's DNA all over it. Yes, there would be. But guess what? I've never used it to kill innocent people. Now have I, Mr. Brian Kohberger? You'd never cut it as a Marine because you can't keep track of your gear. Anyway, other items found during searches included 2 identification type cards belonging to women who were former acquaintances or co-workers of Brian Kohberger from his time as a part-time security officer in Pennsylvania's Pleasant Valley School District. Both women were contacted and confirmed that no harm or threats had ever been made to them. However, they were unaware of how Kohberger obtained those items. Well, Thompson also outlined the team's trial preparation, including initial plans to call Kohberger's family members, such as his older sister Amanda or a parent, as a witness. However, they ultimately decided against it, even after securing a court ruling allowing the family's attendance. Kohberger's parents and sister attended the change of plea hearing and the sentencing hearing, where emotional victim impact statements elicited some visible reactions. Anyway, the prosecutors expressed confidence in securing convictions on all counts and pursuing the death penalty if no plea was reached. This certainly was a case where the death penalty was appropriate, Thompson asserted. And if we ended up going through trial into the penalty phase, I think under the law, it met the elements. Idaho law permits capital punishment for aggravated first-degree murders, and Thompson noted that the case aligned with statutory criteria, including multiple victims and, well, the heinous circumstances surrounding the murders. So despite this, the plea deal was accepted to ensure swift justice and closure, avoiding a protracted trial. And Thompson, who has served since 1992 and ran unopposed for a 9th term to oversee this case, emphasized professional detachment from personal views on capital punishment, accepting it as legislated policy, which is code for I don't believe in it, but I got to follow the law. Anyway, he faced criticism from the Gonsalves and Karmelo families for bypassing a potential death sentence, but maintained that the outcome aligned with evidentiary strength and public interest. He said, quote, "We did our job," unquote. He stated regarding all this scrutiny on the case. Now, the cell phone data and surveillance further corroborated Kohberger's presence. His phone pinged near the victim's home some 23 times between July and November of 2022 during late night hours and was deactivated during the murders, just coincidentally, and then before being reactivated in the Moscow area. Now, newly released body cam footage from the August 22 traffic stop on the Pullman-Moscow highway, capturing Kohberger admitting to not wearing his seatbelt and insisting on his honesty, right? I'm being honest, I didn't have it on, would have been used to identify or verify his identity and the vehicle and his phone number. Now, with the case resolved, Thompson plans to evaluate his future in office, having prioritized his completion. Now, the revelations provide a little deeper insight into the investigation's complexities, underscoring the role of forensic evidence and strategic decisions in achieving accountability for Mr. Kohberger. DNA, ladies and gentlemen, DNA. Would have taken them a little bit longer to get there if they didn't have it. DNA, it bears silent witness. It's there. And even the defense had no good reason why they could explain his DNA just happened to be on the knife sheath. On this little button here, I think it was right here on the inside, underneath the bodies, underneath a body. The defense knew they couldn't explain that away, ladies and gentlemen, and their challenges to the DNA, they couldn't dispute it. And that's why the defense, folded. Next, take a look at this terrifying mugshot released for the suspect in the Devil Dens murder. All right, so police have released a new mugshot of James Andrew McGann, the 28-year-old elementary school teacher accused of capital murders of Clinton Brink and his wife, Kristen Brink, in a remote area of the Devil's Den State Park there in Arkansas. Now, this image depicts McGann in an anti-suicide smock, underscoring the gravity of the charges against him. Now, investigators have confirmed that McGann had no prior connections to the victim, raising concerns that the killings may have been an random act of violence reminiscent of the, Brian Kohberger case involving the murder of the 4 University of Idaho students. Well, this incident occurred on Saturday when the Brinks were discovered deceased at approximately 2:40 p.m. on a secluded trail. Tragically, the couple's 2 young daughters, aged 7 and 9, were present during the attack, but emerged physically unharmed. They are now in the care of family members. Now, this heinous act, executing parents in the presence of their children, represents a profound moral atrocity, inflicting not only immediate terror, but also lifelong psychological scars on innocent witnesses. And the deliberate targeting of a family in the moment of vulnerable highlights the depth of depravity involved, stripping the children of their parents' protection and exposing them to unimaginable horror. Well, McGann, who recently relocated from Oklahoma to Springdale, Arkansas to take up a teaching position at the Bayari Elementary School, was arrested without incident on Wednesday afternoon while at a local barber shop. He faces 2 counts of capital murder, which could result in the death penalty if convicted. Now, Arkansas State Police Commander Major Stacy Rhodes declined to disclose a motive, stating only that the investigation remains ongoing. Evidence collected includes photographs of hair clippings at the salon and a vehicle matching on scene leaving the park with obscure license plates shortly after the murders. The Brinks had recently moved from Montana to Prairie Grove, Arkansas, and were described by friends as kind and genuine individuals. A close acquaintance, Danica Harrell, expressed profound bewilderment at the tragedy, noting the victims' protective instincts towards their daughters during the assault. Law enforcement believe that the couple died while attempting to shield their children, an act of selfless bravery and senseless violence. Now, prior to the move, McGann taught 5th grade in Broken Arrow Public Schools in Oklahoma, departing midway through the 2023-2024 school year for undisclosed reasons. He passed required background checks for his new role in Arkansas, and officials confirmed he had no contact with students there as the school year had not yet started. Now, McGann also had reported ties to a school district in Texas, though details remain rather limited. Now, the randomness of the attack amplifies its evil. Now, a family outing transformed into a scene of brutality, the children forced to confront the irrevocable loss of their parents. Such crimes erode social trust and underscore the urgent need for vigilance against unpredictable threats. Now, McGann is scheduled for a court appearance on August 1st, where further proceedings will determine the path forward in this rather disturbing case. And our thoughts extend to the Brinks family, particularly the young daughters, as they navigate the aftermath of this profound injustice. So we'll give Mr. McGann the presumption of innocence, which he is entitled to, no doubt. But if the facts are true, obviously a horrific attack on two innocent people. But that's why, if you go for a little hike anywhere, ladies and gentlemen, you need to take something to protect yourself. I don't care if you're going to walk around the park, where you take the dog. Take something. Take a little pocket knife, for God's sakes. You're going into the woods, you take something to maybe deter a bear or a mountain lion. You never know what you're going to come across. There is evil in the world, ladies and gentlemen, and you never know when evil is going to rear its ugly head. Next on the docket, a judge's gag order in the Frisco, Texas stabbing case. A noble attempt to silence the already echoing halls. In a move that might be likened to locking the barn door after the horses have not only bolted, but also hosted a parade. The Collin County Judge, John Roach, has issued a comprehensive gag order in the high-profile case involving the fatal stabbings at the Frisco Independent School District track meet. Now, the order seeks to stem the tide of pretrial publicity surrounding the indictment of Karmelo Anthony, the now 18-year-old accused of murdering 17-year-old Austin Metcalf during an altercation on April 2nd of this year. One cannot help but admire the judicial optimism inherent in such decrees. The gag order, which extends its reach to an impressively broad cast of characters, including attorneys for both the defense and prosecution, witnesses, expert consultants, law enforcement personnel, courthouse staff, court-appointed officials, and even family members of their spokesperson, declares that excessive pretrial publicity poses a serious risk to the fairness of the trial. A valid concern, to be sure, but yet it arrives fashionably late to a conversation that has already dominated headlines, social media feeds, and public discourse for months. Well, the legal experts, ever the voice of measured reason, note that such orders are routine in cases of national notoriety. They serve to protect the integrity of the proceedings, much like the gag order in the Brian Kohberger case, right? Anyway, rest assured the public will eventually glimpse the full narrative. For now, however, the judge has decreed a information freeze as it is pausing the viral video mid-frame. Now, compounding this exercise in containment, Judge Roach also issued a protective order on the same day, mandating that the Frisco Independent School District surrender personal details of student witnesses present at the stadium during the incident. And this information apparently encompasses educational records, financial transactions, medical histories, and criminal or employment backgrounds. And that will reside in a secure court file accessible solely to attorneys representing the defendants or the prosecution. I'm not sure why all that gets turned over. It's completely irrelevant. I'm not sure. Any external inquiries require explicit court permission, ensuring that at least some fragment of privacy remains shielded amid the broader spectacle. Now, the incident itself, now etched into the annals of this year's most discussed murder cases, unfolded during a routine track meet when Anthony, then 17, allegedly engaged in a fatal confrontation with Mr. Metcalf. Arrested on the day of the stabbing, Anthony was ultimately indicted for first-degree murder by a Collin County grand jury back in June. Now, he's been released on a reduced bond and is confined to house arrest, and he's been there since April 14th. And of course, if he loses, he faces a potential sentence of 5 to 99 years or life in prison. Now, the jury trial remains slated for June 1st, 2026. Now, with the gag order poised to linger until its conclusion. Violators beware, they may incur fines or sanctions. Now, both families have already contributed their perspectives to the public record, a detail that underscores, well, the absurd nature of this order. And in an attempt to muzzle the cacophony, the court inadvertently highlights how much has already been said. One might ponder, in an era where information spreads faster than judicial ink dries, is a gag order a safeguard or merely a ceremonial nod to decorum? The trial will tell. But until then, the silence, such as it is, shall reign. We've seen the affidavit for the arrest warrant. We haven't seen the video. We know there's witness statements. It's not a complex case. And I'm sure there's video. There is video. A gag order? Now, maybe they're trying... Mr. Anthony's got the family spokesperson that's out there saying it was all racially motivated and he's the victim and he was defending himself. And I get it. Both sides shouldn't be discussing it, but that's what good lawyers do, is try to contain their clients and exercise some client control. But I guess... I'm trying to think. Protective orders happen all the time. You can't disseminate discovery. Certain information is redacted, prohibited from being released to a defendant. I get that. That's cool. Understand that. But to have a gag order, I think I've had maybe 2 cases in 30 years where a gag order has been imposed. And the one I did, it was a horrible case. It was a priest that was doing terrible things to children. And I asked for it just because I didn't want the prosecutors out there, dumping facts out there for the world to see. But that was even the day. That was when there was like 2 newspapers in town, and there wasn't social media like there is today. So I think it's an outdated notion, but what can you do? Because attorneys are already bound by their professional ethics not to do anything that's going to influence the case. Next on the docket, Florida ascends to the pinnacle of peril, on task to shatter its own macabre milestone in executions, right? In a display of unwavering commitment to leading the nation in matters of finality, Florida is poised to claim the crown as the undisputed champion of capital punishment this year. Now, with the scheduled execution of Edward Zakowski, a man convicted in the 1994 machete murders of his wife and 2 young children, the state will notch its 9th execution in 2025, eclipsing the previous high watermark of 8 set in 2014. Not content to rest on such laurels, Florida has lined up a 10th for August 19th and an 11th on August 28th, ensuring its dominance in the somber arena remains unchallenged. Now, Governor Ron DeSantis, ever the efficient administrator, has issued the requisite death warrants for 60-year-old Air Force veteran, directing that Zakowski meet his end via lethal injection at 6 p.m. on Thursday at the Florida State Prison in Stark near Gainesville. The United States Supreme Court, in a decision as swift as it was unyielding, denied his final appeal on Wednesday, clearing the path for the record-breaking event. Now, Zakowski's crime, committed in the wake of his wife's divorce filings, paints a picture of calculated brutality. He reportedly assaulted the 34-year-old Sylvia with a crowbar, ladies and gentlemen, and then a rope before turning machete on their children. Edward, who is 7, and Anna, 5, and ensuring his wife's demise with the same blade. Trial accounts reveal he had confided to others his preference for annihilation over separation, a grim prelude to Florida's own brand of state-sanctioned closure. Now, opponents, in a nod to irony, highlighted Zakowski's military service and the jury's narrow 7-5 recommendation for death, a margin that would fall short under today's laws, where unanimity is required. Yet the trial judge imposed the sentence regardless, underscoring the evolving, if not always progressive, nature of the justices in the Sunshine State. Now, advocacy groups like the Action Network had rallied with petitions and scripted pleas to DeSantis, arguing that such acts merely perpetrate violence without enhancing safety. Justice does not require death, they instone. though Florida's ledger suggests otherwise. This year's tally places Florida far ahead of rivals, with Texas and South Carolina trailing at 4 executions each. Nationally, 26 individuals have met court-ordered ends thus far in 2025, with 11 more slated across 7 states. Florida's most recent contribution was Michael Bernard Bell on July 15th after forthcoming warrants for Kaylee Bates, a 1980 abduction murder, and Curtis Wisdom for the 1992 triple killings, promises to extend the streak. Now, experts attribute this surge to assertive Republican leadership expending appeals, coupled with presidential executive orders reinvigorating federal pursuits of the death penalty, and Florida's protocol, a trio of drug-inducing sedations, paralysis, and cardiac arrest, remains the method of choice, administered with precision one might expect from the state that prides itself on efficiency, even in extinction. Now, in the theater of the terminal, Florida stands alone at the summit, a testament to its unparalleled prowess in concluding chapters with irreversible finality. Next, Alec Baldwin. Remember him? Well, he filed a civil suit against the prosecutors in his criminal case. Well, yeah, his case, it fired a blank. What a hoot in the courtroom circus. Alec Baldwin, the king of dramatic flair, slaps down a lawsuit claiming malicious prosecution and civil rights shenanigans over the tragic Rust shooting back in 2021. But hold on to your wigs, folks. A New Mexico judge just tossed it out like yesterday's reheated chili, dismissing the whole shebang without prejudice because, get this, nothing much happened with the claim since it was filed earlier this year. Now, Baldwin's legal eagles have 30 days to beg for a do-over. Anyway, the judge's ruling hit the public eye on Wednesday, and Baldwin's top attorney, Luke Nikas, shrugged it off in an email to the Associated Press like it was no biggie. "We've been chit-chatting settlement in good faith," he basically said, "and if that doesn't pan out with balloons and confetti, we'll refile faster than you can say cut." Well, the villains in Baldwin's tale. That's right. The special prosecutor, Carrie Morrissey, Santa Fe District Attorney Mary Carmack Altwise, a trio of bumbling investigators from the sheriff's office, and even the county board of commissioners. Talk about the casting a wide net for blame. Rewind to last year. Baldwin's involuntary manslaughter charge got the boot mid-trial when it turned out cops and prosecutors played hide and seek with evidence. Some random guy waltzed into the sheriff's office with ammo that might have been linked to the death of the cinematographer Helena Hutchins, and poof, the whole case imploded like a bad special effect. Anyway, Baldwin's lawsuit threw in some juicy defamation claims, accusing the prosecutors and sleuths of gunning for him just to boost their careers or score political points. Meanwhile, poor Helena Hutchins met her untimely end during a rehearsal on the Dusty Rust set outside of Santa Fe. Baldwin insists he only yanked the hammer, not the trigger, and bam, the gun went off rogue, wounding Joel Souza as well. Now, still, the Hutchinson's family isn't letting go. They're suing Baldwin and the Rust producers in state court, with his deposition postponed. Moral of the story, in Hollywood's Wild West, sometimes even the lawsuits fire blanks. Next on the docket, this day in legal history. July 31st, 1789, the first Congress enacts the Fifth Act, creating 59 custom collections districts in 11 states, establishing the United States Customs Service, an early fiscal and regulatory infrastructure used to enforce revenue laws and tariffs enforcement from the start. On this day, 1933, the federal prison system expanded. That's right. The Department of Justice finalized plans to transfer control of federal prisons from the Department of the Interior, with new regulations issued for facilities like Leavenworth. This regulatory action, effective July 31st, improved oversight of federal inmates and prison-related crimes. On this date, the Federal Firearms Act amendment was signed. That's right. President Lyndon Baines Johnson signed amendments to the Gun Control Act of 1968, strengthening regulations on interstate firearms sales and criminalizing possession by felons. This responded to rising gun violence and assassinations, enhancing federal prosecution powers. And on July 31st, 1975, Congress approved the Federal Rules of Criminal Procedures Amendment Act, formally ratifying significant changes proposed by the United States Supreme Court affecting criminal procedure rules. For example, Rule 11 and others. And on July 31st, 2020, the United States Supreme Court issued a procedural order dismissing several pro se motions in a criminal case, stating that the represented defendants' motions were moot since counsel had been appointed, reflecting case management rule enforcement. Yes, yes, ladies and gentlemen, you cannot file pro se motions when you are represented by an attorney, whether it's yours that you're paying or two, even if they're court appointed. You can't file a motion with the court. The court won't consider it because you have an attorney. If you want to go pro se and pretend you're going to be a lawyer, then you need to file a motion to proceed pro se. That one will get everybody's attention, I assure you. And they will try to talk you out of it, like they should. But most people that want to go that route, well, that's right. They are going to charge forward. And then when it gets real, they say, ooh, can I have an attorney again? Because they know they're going to get their butts kicked. Ladies and gentlemen, I always tell people, whether you hire me or somebody else, always get yourself an attorney when you go to court. How do you know if you're getting a good offer? What if you're innocent? You don't want to plead guilty to something you didn't do. The prosecutor is not your friend. He's not there to give you legal advice. Think about that. Next, our legal quote of the day has to do with sometimes the two-tiered legal system. Quote, we have a system of justice in the U.S. that treats you much better if you're rich and guilty than if you're poor and innocent. Wealth, not culpability, shapes outcomes, end quote. Now, this statement underscores the systemic inequalities where financial resources influence legal outcomes more than actual guilt or innocence. Can't necessarily say I disagree with that, but yes, if you're in custody or you qualify as indigent, you're going to get competent counsel. But if you're in that donut hole where you're not in custody, you're not indigent, but you can't afford top-notch counsel, you could wind up, hurting yourself. So yeah, it's, sometimes it's better just to stay in custody and get your court-appointed counsel some days. And next on the docket, in the sun-drenched expanses of Florida state forests where the air hums with the subtle threat of wildfires and the vigilant gaze of guardians, one audacious individual has earned the dubious honor of Dumb Criminal of the Day. Allow me to regale you with the tale of the hapless thief who dared to pilfer the very symbols of Smokey the Bear, only to find himself ensnared in a net of irony thicker than the underbrush he traversed. Our protagonist, let's call him the Bear Bandit for narrative flair, and his true identity remains discreetly veiled by authorities, embarked on a grand tour from the panhandle haven of Pensacola to the bustling heart of Orlando. His quarry, not hidden treasures or elusive wildfire, but the iconic signs bearing smoky stern warnings. Only you can prevent firefighters. Now, these pilfered placards, emblematic of national fire safety campaigns, were properly listed for sale on Facebook Marketplace at the price of $1,900 each. One might ponder the market demand for such stolen memorabilia, perhaps among collectors of iconic lawn ornaments or enthusiasts of bureaucratic kitsch. But the bandit's entrepreneurial spirit was as bold as it was misguided. Enter the Florida Agricultural Commissioner, Wilton Simpson, whose rhetoric query encapsulates the absurdity. What happens when dumb criminals poke the bear? Indeed, the proverbial bear was poked, and it roared back in full force with law enforcement. Assisted by none other than Smokey himself, or more precisely, a representative embodying the Ursine icon, the authorities apprehended the suspect in a scene that blended farce with justice. As Simpson recounted with a touch of bemused exacerbation, Smokey got lucky today that he saw the bad guy and got him handcuffed. The bandit, now en route to a jail cell, faces potential charges and incarceration, a fitting finish to his ill-conceived venture. Now, Simpson's commentary further illuminated the folly. What an idiot. He marveled at the audacity of stealing an image so universally revered, known to school children, family, and citizens nationwide, and attempting to profit from it. In a state that prides itself on robust fire prevention, having conducted controlled burns across 277,000 acres and invested $93 million in equipment last year alone, such crimes strike at the core of public safety efforts. Smokey, ever the dutiful sentinel, continues his rounds educating the populace on averting the 24,000 acres of destruction wrought by wildfires in the previous year. The moral of this satirical saga: if one must engage in nefarious activities within Florida's forest, wisdom dictates avoiding the dominion of a bear who has been synonymous with vigilance since 1944. As Mr. Simpson aptly warned, if you're going to go in and commit crimes in our forest, you probably need to find a different place. Not only will you find smoke in some of those forests, but you'll find officers. In this pro-law enforcement stronghold, even Smokey Bear stands ready to enforce the law, proving that some criminals are not merely dumb, are spectacularly so dumb. Unidentified Smokey the Bear stealer, you are a dumb criminal of the day. All right, ladies and gentlemen, that's all we have for you today. Thanks for watching. We'll see you next time. And remember, the Constitution matters.